Hello, everyone. My name is Tom, a business consultant at Asian Inc. Today, I am joined by my colleagues Laura, Stephen, and Daniel from Raff Law. Thank you for tuning in for today's pre-recorded webinar, Business Entities and How to Form Your Business. While this session is not live, you can still submit any questions or comments using the contact information provided at the end. At any time during this session, feel free to pause or rewind as needed to follow along at your own pace. This webinar will also be available on all of our social media platforms and YouTube for future viewing. We hope you find this session valuable. My colleague Stephen will now talk a little bit more about Asian Inc.
Asian Inc. is a San Francisco-based nonprofit that empowers equity through affordable housing, financial literacy, and business development. We are part of the business development team, and we focus on promoting the growth of local, small, and socioeconomically disadvantaged businesses through access to capital, access to procurement contracts, and access to new markets. Follow us on social media for the latest updates on affordable housing, financial literacy, and business development information. If you'd like to become our client, scan the QR code on the left or contact us directly at our office or by email. Without further ado, please allow me to introduce today's speaker, Daniel Raff. Daniel Raff is the founder of Raff Law APC, where he provides personalized, high-quality legal services. His practice spans real estate, business, and civil litigation, and including drafting complex legal agreements and resolving disputes. Before launching his firm in 2012, Daniel gained valuable courtroom experience working in several Northern California prosecutors' offices, including serving as the deputy director attorney in Solano County. Daniel, the floor is yours.
All right, thank you. I'm going to get this slideshow started. Give me 1 second here.
Okay.
Maybe I can get Zoom to cooperate. Okay. I need to do that and then share and there and there we go. And there we go. All right. So thank you for that introduction. I appreciate that. I am here to talk about, I have a few topics to go through here. We're going to start with a short legal disclaimer. I'm a lawyer after all. You guys can feel free to read it. But basically, me giving this presentation doesn't create the attorney-client relationship with anybody. If you're confused about that, please let me know if you have any questions. All right, moving on. We have three main topics that I'm going to be discussing today. We have business structures, intellectual property, and when should I contact an attorney? We're going to start with business structures. There's a lot to go through. All right. So business structures can affect a few different things. As you can see on the slide, certain structures will protect your liability while others, or will protect your personal assets, so your personal liability, while others will not do that. It can affect how your taxes are set up, and it can affect the business's relationships with owners and third parties. We're going to start by talking about the protections that certain business structures have for the personal liability of the owners. I've broken down the most common business structures that you might encounter into this little slide here. I'm going to talk about all of them, but we're going to start by talking about the basic structures. So the basic structures are sole proprietorships and general partnerships. With a sole proprietorship, you as the owner are the business. There is no legal distinction between you as the owner and you as the business. And that has a few different consequences. The first one, so that's you as the owner. You can see that there's a little equal sign. The business is the same thing as the owner. What that means when there is potential liability is that there is no distinction between the two. So for example, you own a bunch of property. So you've got, in this little example, we've got the owner having real estate. They've got personal property in the form of a car and savings. The business has its own assets in the form of equipment and supplies. And we're going to have but somehow this business ended up aggravating somebody and they ended up getting sued. So this is my plaintiff. I've been doing this presentation for a little bit, and every time I've done this part of the presentation, I always go online to check to see if I can find a more interesting photo for that. And I found that like 10 years ago, and it's just such a perfect photo for a plaintiff. I've never quite been able to change it. But anyway, so you have a plaintiff that comes in and they are going to sue the business. If that plaintiff is successful and establishes that the business did something wrong, because there is no distinction between the business and the owner, that little red line, that lawsuit, is going to that plaintiff is going to have access to not just the business's assets, but also the owner's assets as well. So if the lawsuit is big enough, that person can end up losing their real property. They can end up losing their savings. There's certain types of savings accounts that are protected, such as ERISA accounts, but like 401ks, assuming that it's not an individual 401k. But the point here is that when you are a sole proprietor, your personal assets are on the line. It is not like investing in, Microsoft, or maybe PG&E is a better example, right? If you had invested in PG&E, sure, you could lose the money that you invested, but you know that your personal assets are safe. That is not the case when you're a sole proprietor. PG&E is a corporation. If you are a sole proprietor, if you have not set up a corporate structure, your personal assets are on the line. So, I will get to the distinction in a little bit. Before I get to that, though, I'm going to talk about another very similar type of setup, and that's a general partnership. So if you have a partnership, in other words, if you're working with another owner and you do not have anything set up, you don't have any paperwork, you haven't set up an LLC or a corporation, by default, you will end up in a general partnership. When you have a general partnership, it basically works the same way, except you have more than one person. So again, there's not really much of a distinction between the partnership and you as an owner. So in this little example, we've got one partner who has real estate and some savings. The other partner has a car and some real estate. And all of this is going to end up being connected. So when you have a plaintiff that comes in and is upset and is able to secure a judgment, that plaintiff is able to get at the personal assets of both owners. There is no distinction. There is no barrier between the business and the owners themselves. And that is how it works for basic structures. There is also one important component of a general partnership that you should be aware of, and that is joint and several liability. Joint and several liability. So when you have a general partnership, each partner is jointly and severally liable for the debts of the partnership. What that means is each partner owes 100% of the debt. So when you have a general partnership or any situation where you have joint and several liability, a creditor can go after the partner for the entire amount. In other words, if you get into business with the wrong person and they end up and someone gets a judgment against the partnership for, let's say, $1 million, and that person, disappears and goes to some place where there is no extradition treaty, the creditor or the claimant can go after you for the entire $1 million. It's not like they're limited to just getting half of the amount that the partnership owes. That's what joint and several liability means. Each partner is liable for 100% of the debt. Now, if that happened, if you did end up paying the full, in my example, $1 million, you could sue the other partner for what's something called contribution, but that's going to be on you, and that's not a position that you're going to want to be in. The next little point here is that a general partnership means that any partner can bind the partnership. So not only do you have joint and several liability, but you really have to trust this person that they're not going to go rogue and do something really weird. So if your partner does go rogue, you're going to be on the hook for whatever they end up doing. General partnerships are not advisable from a liability standpoint. So what are your other options? We talked about the basic structure. Now we're going to talk about limited liability entities. The difference here, so we're going to have the same situation. In this little diagram or these little drawings I have, we've got two owners, but this time, instead of being general partners or sole proprietors, they are going to be shareholders in a corporation or members in an LLC. When you have a limited liability entity like an LLC or a corporation, you have something called the corporate veil. Corporate veil is a term that lawyers use to refer to the distinction, this barrier that is created for limited liability entities between the business and the owners of the business. So in this case, plaintiff is going to show up, sue the business, but now this plaintiff is going to be limited to the assets of the business. You can see that the shareholders are, while they might lose whatever they invested in the business, the little red line does not extend to their personal assets. Their savings, their real estate, their car is safe. And just to provide a little example, you can see the comparison between the two structures. With the basic structure, your personal assets are on the line because there is no distinction. There is no legal distinction between you and the business. Whereas with a limited liability entity, you have the corporate veil, and the corporate veil protects your personal assets. Now, I should also mention that in order to get that liability protection, you do need to there are certain things that you need to do, and it is possible to get through the corporate veil. That's called, the term of art that lawyers use for that is called piercing the corporate veil. But if you do things correctly, that corporate veil should protect you. And that's the reason why you generally want to use a limited liability structure. So here we have the corporate veil. It protects your the assets of an owner from creditors in limited liabilities, in limited liability entities like corporations and LLCs. So that is the first component. Business entities can affect your personal liability as an owner. If you're running a business, you generally want to set it up with a limited liability entity. We'll come back to when that might make sense in a little bit. But the next topic we have to discuss is your taxes. The entity that you use can affect how your business is taxed. So let's start with the basic structure again. So in this example, we have customers coming in, they pay money to the business. Now, because the business is the same as the owner, there is no legal distinction again. All of this will flow through onto the owner's income tax, basically their 1040, their income tax return. So the owner will end up paying income tax and self-employment tax on the amount that they earn. For those of you that don't know, the self-employment tax is also known as the FICA tax, also known as Social Security and Medicare taxes. It is the tax that everyone has to pay on any earned income that they make. For employees pay the payroll tax. All of these are names for the same thing. It's money that's used to fund Social Security and Medicare. And again, you pay it on any earned income. Because for a sole proprietor or for a partner in a partnership, there is no distinction between you as the business, because there is no distinction between you as a worker or you as a business owner. It's all wrapped up in the same thing. You are the business is you. The entire amount that you make as a sole proprietor is considered to be earned income and therefore subject to the self-employment tax. So let's take a look at some other possibilities. So next we're going to talk about C Corps. These are corporations that corporations by default are taxed as C Corps as opposed to S Corps, which I'm going to get to in a minute. But when you have the default tax set up, you have customers that come in that pay the corporation. The corporation then has expenses. So these expenses, this can be rent, this can be a lot of different things, but one of those expenses is going to be wages. Wages would be paid to employees. The employee is going to have to pay income and payroll taxes on any money that they make, but that is on their individual return. After expenses are taken out from the corporation, you get your net profit, and then the corporation has to pay corporate taxes on their net profit. If the corporation then distributes any of those profits to shareholders, the shareholder will have to pay capital gains tax on the amount that is distributed, or in some circumstances, it's ordinary income tax. So this is how, with C Corps, you end up with a whole bunch of different taxes. So it's obviously a lot more complicated with a sole proprietorship. But you also have multiple layers of taxation. You've got taxation for the amount that's paid as an employee, or that's paid to you as an employee. You have a taxation on the amount that the corporation makes, and you have taxation when the corporation distributes any of their profits to shareholders in the form of capital gains tax that the shareholder has to pay. Generally, if you are an owner operator of a business and you're set up as a C Corp or as an S Corp, which I will get to, you will need to put the IRS will require that you put yourself on salary, and you have to pay yourself a quote unquote reasonable salary. So you will likely end up paying yourself something as an employee. So you'll end up paying income and payroll taxes on that amount. And if you have a C Corp, then you're also paying taxes, corporate taxes, and this capital gains tax. Let's compare it to an S Corp. With an S Corp, you can see it skips that middle section where the corporate taxes were paid out. Instead, the net profit flows through the corporation and lands onto the shareholder's personal income tax return, and the shareholder pays income taxes on the amount that that the business made. So on the next slide, I have a little comparison between the two. I know this is a little busy, but I had to squeeze in a whole bunch of different things. So starting at the top, you've got a sole proprietor who is paying income tax and self-employment tax on the entire amount that they make. For a C corporation, you have a different tax structure. So a owner-occupier is going to pay themselves as an employee. Then there's going to be a net profit where you pay corporate taxes on it. And then if they end up distributing that money to themselves, they're going to pay capital gains tax on it. Then we have the S Corp. With an S Corp, it looks pretty similar. Well, I guess it's kind of a hybrid between the two. But one thing I want to point out here is that you can see that as compared to a sole proprietor, where the entire amount is subject to income and self-employment tax, for an S Corp, for an owner operator of an S Corp, while they do have to pay themselves some amount as a salary, and that amount is subject to income and payroll taxes, the amount that they make as net profit on the business They do have to pay income taxes on it, but it is not subject to the self-employment tax or the payroll tax. In other words, they are saving money. They are not paying that tax. So here's a little comparison that I've got for you here. With a sole proprietorship, all profits are subject to both income and self-employment taxes. Then you have a little explanation for a C corp, and then for an S corp, the owner operator pays income and payroll taxes on their salary, but they only pay income taxes on the profits. Most small businesses, when they hit a certain threshold that I'll talk about in a little bit, end up converting into a S corp because there's tax savings, because they don't end up having to pay those self-employment taxes on the amount that the business makes. So I have another little comparison here. First, like I had at the beginning of this presentation, there is a little bit of fine print. This is a very simplified version of the math on all of this. There are certain things that it does not take into account just to make the math simpler. Your situation can and will be different from this. You need to talk to a tax professional. I'm not a tax professional, but this gives you an idea of how this tax saving works. In this example, an S corp is going to end up saving almost $12,000 in taxes as compared to a sole proprietor with the same numbers. That's a big benefit and a big reason why people end up creating an S corp. All right, so these were the basic structures that we talked about. I've now gone through and talked about the sole proprietorship and the general partnership, and the C corp and the S corp. I have not talked a lot about LLCs, limited partnerships, LLPs, and professional corporations. These are special entities that are only useful in particular circumstances. Well, actually, let me back up. So the LLC is effectively a hybrid between a sole proprietorship or a partnership or a sole proprietorship in a corporation. It allows you to have the limited liability structure that a corporation does, but it allows you a lot more flexibility in terms of how it's taxed and how it's run. LLCs can choose to be taxed as sole proprietorships or as general partnerships. Corporations cannot. LLCs can also choose to be taxed as corporations if they want to. They get to choose how they want to be taxed. So a lot of people like the flexibility both in terms of taxes and the governing structure, which I'm not going to talk about too much. It's a little bit easier to operate an LLC than it is to operate a corporation. I will come back to that issue in a little bit, but let's talk about these other structures. So we've got a limited partnership. A limited partnership is the way that it works is you have a general partner or more than one general partner and a limited partner or more than one limited partner. The limited partner gets a liability protection. The general partner does not. There are certain very specific circumstances where this might come up, where it might make sense to do that. Most businesses, that is not going to be the case. Usually it has to do with certain investment vehicles. For a professional corporation and LLPs, these are entities that are used for professional services. So for example, my business is set up as a professional corporation. There are a lot of law firms that are set up as limited liability partnerships. They generally operate pretty similarly to what I've kind of already talked about. If you are in one of those specific circumstances, I'm happy to talk about them. All right, so we've talked about the liability, limiting personal liability. We've talked about taxes. The only thing that's left is talking about your business's relationship with owners and third parties. So going back to this slide. For everything that we've been talking about, generally the people that are in charge, so let's take a corporation, for example. With a corporation, you have shareholders who elect the board of directors, who then appoint officers. And then the officers kind of run the business. Well, the directors in that example have a fiduciary duty to the shareholders to maximize their profits. That's what their obligation is. And that is their guiding principle. How do we make the most money for the owners? That's also true when you have partnerships. You have an obligation to try and maximize value for the other partners, and that's true for LLCs and all of this stuff. But some people don't want to necessarily do what will maximize the most value. And that's where these last three entities come in: the B Corp, the co-op, and the nonprofit. A B Corp, instead of having shareholders, they have stakeholders, which will generally include the owners, but it also might include the employees. It might include certain components of society that you want to be served. So in those with a B Corp, it allows what a B Corp does is it allows flexibility in terms of trying to figure out not just what's in the best, not just what is going to maximize the most money, but what is in the best interest for all of these different stakeholders that somebody wants to use. Generally, there are very limited circumstances where you would want to use a B Corp. Often a B Corp there are better vehicles for whatever you want to do, either by having a fully for-profit enterprise like a regular corporation, or if instead you might want to use one of the other two entities that are listed here, which are co-ops and nonprofits. So a co-op is a business that is basically owned by the employees, and there are certain benefits for having that. There are certain, and this is true for B Corps too and nonprofits, but there's certain grants that you can get, that kind of stuff. I'm not going to go too far into detail on that, on how all these work, because the basic structure is sort of the same, except who the owners are and what the relationship between the owners and the rest of the company and third parties. That's the only thing that's really differentiated. You can also have a nonprofit. There are a variety of different types of nonprofits, the most prominent being a 501c3. Benefit of having a nonprofit and a 501c3 is that the money that is made is or the money that is contributed to it. In other words, if any money that's donated to that entity is deductible. For other nonprofits, there are like trade associations, for example. My guess is that Asian.Inc. is probably organized as a nonprofit under one of the other code sections. But it is a different type of structure for a different type of enterprise. If you are a small business owner, you're probably not going to want one of these other ones, but if you have more questions about that, I'm happy to talk about that. You can reach out to me, and I'm happy to answer those questions. So, oh yeah, so those are the three that we need to talk about. So now we get to some frequently asked questions. The first one is, when does it make sense to incorporate or organize a LLC? The first circumstance under which you definitely absolutely should be looking at this is if you have substantial assets outside of the business. So even if the business is not that big, even if you're just starting out, but you have a lot of assets outside of the business, those assets can be a target for somebody. So you want to protect those personal assets that you have. So if you have significant assets outside of the business, whenever you start the business, I would just immediately go forward and start it as an LLC or corporation. Next, if your net profits are above $80,000, this is going to vary depending on who you are, depending on your particular circumstances, but this is a good kind of rule of thumb for whether or not you can save money by incorporating. So if you have net profits above $80,000, you probably can save money by incorporating and using that as the S Corp that I talked about earlier. Next, if you are doing high liability work, so the example I use here is contractors, but if you're in a field where you're likely to get sued, that is a important consideration in terms of whether or not it makes sense for you to incorporate. Next, if you have partners or employees. Partners and employees are a big source of liability for a business. And as a result, you should seriously consider incorporating if you have a partner or an employee. The other thing that you need to do if you have a partner is you need to have a partnership agreement. And if you're going to go in to get a partnership agreement, you might as well get the whole entity set up anyway. It will generally be not a lot more expensive. It will generally be close to the same price as just getting the partnership agreement put together. All right. Next, when should you use an LLC versus a corporation? As I mentioned earlier, LLCs offer more flexibility in terms of government and governance and taxes. But LLCs are not available to all businesses. I am not able, as a lawyer, I'm not able to use an LLC. I have to use a professional corporation. And certain businesses have like specific requirements that might dissuade someone from using an LLC. As I mentioned here, contractors need an additional bond for an LLC, which most people don't want to pay because they don't need to. Instead, they can just set up a corporation. And there are slight tax differences for all this stuff, so you should talk to a tax professional. Next, why shouldn't you just do this all online? First, online services don't provide legal advice. And the liability protections require ongoing processes. So what ends up happening with this is that people will use like LegalZoom or something to set up the LLC or to set up the corporation, but they won't keep it up. And as a result, they just wasted a whole bunch of money putting everything together. I have never seen, I've been doing this for a little while, and I've looked at a lot of business entities that people have set up on their own using one of these services. And I have never seen one where somebody set it up correctly. You should have a lawyer put this together for you. And it will help you make sure. And part of what it will do is the lawyer, or at least when I do this for a client, I sit down with them and I make sure that they understand everything and they understand what they need to do moving forward in order to make sure that they maintain the corporate veil. So what ends up happening when people use online services is that they create what I call an empty shell. It looks like they created an LLC or a corporation, but if they haven't done things to keep it up, it is not going to give them that value. And if that's the case, they would have been better off just going online and filing the articles themselves. That is a very easy process, and it is not expensive, and you can absolutely do it on your own. You just go to the California Secretary of State website. And usually when people set up a corporation or an LLC through one of these services, that's where they stop. That's all they end up doing. And if that was the case, you just wasted a bunch of money. You might as well have gone and done it yourself on the website. And what often ends up happening is that you end up paying the same price to fix things later. So because people they do it on their own, and then eventually they realize that they probably need to fix it up. They go in and talk to an attorney, and it generally will cost more to fix it rather than to just have done it right from the first place. The last little bit on here, the last little answer that I have on this is that the cost of hiring an attorney is very small compared to the risk that you are protecting yourself from. Offering or setting up an LLC, setting up a corporation will protect you from business litigation, will protect your personal assets from business litigation. And if we're talking about a business that is generating, $100,000 a year, the cost for hiring an attorney for a one-time cost of a couple $1,000s is insignificant compared to the 100,000 plus the next year's 100,000 plus the ongoing amount that you're making. It's very small, and a lawsuit can be very expensive. So that's why you shouldn't just do it online. You should pay to have it done right in the first place. Last frequently asked question that I have on here is, why do I need this if I have insurance? This is a question I get a lot. And insurance is great for covering certain claims, but it does have policy limits. And you might not be keeping up with what your policy limits should be. A lot of people discovered that, not so much in the business context, but they discovered that in the when these fires came recently, and they found out that they were very underinsured. That can happen in the business context as well. If you are not keeping up with your policy limits, you can find yourself underinsured, and that can be a big problem for you. But more importantly, insurance has exclusions in their policy. There's a bunch of stuff that they explicitly do not cover. And you need to be very wary of the things that they are saying that they do not cover. That will include claims for breach of contract and intentional torts. So, breach of contract, for example, if the business doesn't work out and you're not able to pay your debts, you're not able to pay your lease, you're not able to pay vendors, that kind of thing. Insurance is not going to cover that. If some deal falls through that where you're not able to deliver and someone ends up on whatever product or service you told them that you were going to deliver, and someone ends up losing a bunch of money on that, that is not an insurable claim. There are lots of lawsuits. My practice is primarily focuses not on negligence lawsuits, but instead on these breach of contract cases. And they can be very expensive. And insurance does not cover that. Insurance is for negligence. It is not for breach of contract or intentional torts. And then my last little bit here is you should have both. Again, these are both I would never tell somebody not to get insurance because you don't need it because you have an LLC or a corporation. But because insurance doesn't cover everything, you should get both. All right. So that ends our little discussion on business structures. We are now going to be talking a little bit about intellectual property. Intellectual property comes in four main types. You've got copyright, patents, trademark or trade dress, which is the same thing, and trade secrets. So we're going to start with copyright. You can read through this slide. I'm not going to go through and repeat everything on here, but basically the idea behind a copyright is it covers like a work of art or work of or writing. You know, books get copyrighted, art gets copyrighted, and it allows you to sell that work without somebody else coming in and basically reproducing it. That's what a copyright does. Oh, and I had a little thing here. So copyright, like an example of a copyright would be books. That is a good example of something that gets copyrighted. If you wrote a book and you published it, and you put it out there, and then I just came around and just copied all the text and then immediately republished it, you could sue me for copyright infringement. That's basically what that is. The next that I'm going to talk about is patents. Patents generally are for ideas or procedures or processes. They're a thing that you make or a thing that you create process for making. The kind of classic example of this would be creating some sort of new type of medicine or medical device or something like that that has some sort of novel technique. So you can patent that, but you can also patent the process that you made for creating it. If you created some sort of novel biotech process for creating different types of, I don't know, medical devices or compounds or something like that, you can patent that process. And then nobody else is going to be allowed to create things using that process. The downside of this is that it only lasts for a limited amount of time. It only lasts for 20 years. That's the deal. You create something new that adds value to our society. You get the exclusive use to sell that or to use that for 20 years. But then at the end of 20 years, it goes into the public domain, and anybody who wants to can start using it. That's how you get things like generic drugs. These are drugs that have made it past their patent and are now available for other people to start reproducing. Next, we're going to talk about trademarks. Trademarks are a way of distinguishing your business from somebody else's. So as an example, this is my logo. This is a trade dress for me. Nobody else is going to be able to come in and use that or use something similar. If somebody made it so that it was so similar that it might be confusing for a consumer to tell whether it's my business or theirs, they would be infringing on my trademark and I could sue them for it. The last one on here is trade secrets. So this is something, as opposed to all of this other stuff that we've been talking about, is kind of in the public, right? Copyrights you don't really have a copyright. Like, you don't have a copyright to anything that is not in the public. That doesn't make sense. I suppose if somebody like stole your writing or something like that and published it, that would technically be a copyright infringement. But it's the fact that it went out into the public is that is what matters. You have the right for using this out in the public. Or with a trademark, the idea is that this is a mark that you are using out in public to differentiate you from other businesses. A patent is something that you register in order to make sure that nobody else uses the same device or process to do whatever their business is or whatever your business is. A trade secret operates differently. This is something that is only known, that is not generally known, and what makes it valuable is that it belongs to you and nobody else knows it. So the example I give here is, this is sometimes a discussion that you might have with a lawyer about whether or not you want to patent something or you want to keep it as a trade secret. If you patent it, you're putting it out in the public domain. That means that you have the exclusive right to use it for 20 years. But after that 20 years is up, it's fair game for anybody, as opposed to a trade secret that you want to keep secret. So, well, that's basically what I just said. The example that I'm using here is Coca-Cola. The recipe, the secret recipe for Coke. That would be a trade secret. They are not allowing other people to know how they make Coca-Cola, so that way they can keep making it and other people aren't able to make it in the same way. Compare that to drugs. I am I suffer from allergies, so I'm familiar with Flonase, but I generally go to Costco and I buy the Kirkland brand version of it, which is the generic of the same thing. Flonase was patented. When the patent ran out, other generics were able to step into that space and sell stuff. Whereas with Coca-Cola, they've been keeping their recipe a secret, and so that is a trade secret. And if that did get out somehow, they would be able to sue anybody who was releasing that information. So let's talk a little bit about intellectual property registration. There are basically 3 different categories that intellectual property will fall into here. The first is for patents. For patents, you don't have a patent unless you register it. That is basically what it is. If you don't register the patent, then you don't have a patent. It is the act of registering it that gives you rights to enforce your patent rights. On the other end of the spectrum, as I said, would be trade secrets. You can't register a trade secret, because if you registered it, then you're specifically divulging that to the public, and that defeats the entire purpose of having a trade secret. In the middle are copyright, trademark, and trade dress stuff. If you register one of these, so by default, you have certain copyright protections, you have certain trademark protections, even if you don't register any of these. You can sue people for infringing on your copyright or trademark rights, even if you haven't registered them. However, there are benefits to registering them, and it is that they confer additional rights. It allows you to kind of declare that this is yours, and it can make things easier if you do end up having to sue someone. So when you're evaluating whether or not to register this is something that probably makes sense to talk about in specific circumstances with your attorney. But the idea here is that you can get additional benefits by registering these rights, and whether or not that makes sense is something to kind of consider. All right. So I have a couple of frequently asked questions for you. When does it make sense to register a copyright or a trademark? Generally, you want to register them when you're expecting widespread exposure. While I would love if my firm ended up taking over the entire country and we had offices in every state and all that stuff, for the time being, we have one office in Petaluma. It is unlikely that I really need to kind of stake my claim to the Raff Law brand outside of the particular area that I'm working in. As a result, I have not trademarked my name. But when I have clients that are going to be selling things on, for example, Amazon, either throughout the country or internationally, then you should be looking at trademarks in getting your trademark registered in order to protect your ability to do business that way or under that trademark. And as I said, you should talk to your lawyer and get advice about that. Next, why shouldn't I just do this online? Similar to my earlier question with on the corporation and the LLC formations. This is a little bit easier to do than LLC and corporate formations. So this one I am less kind of I'm going to push back a little bit less about doing that on here. You can hire a company. You shouldn't do it on your own, but there are companies out there that provide this service, and they do a pretty good job of doing the basic paperwork on it. And you could hire them, and it probably will be less than hiring a lawyer to do all of this. However, if you do that, there could be a conflict. So if you have a trademark that you're trying to register, and it turns out that somebody in like Tennessee has something similar, that could be that the company that a trademark registration company ends up flagging, you may want to talk to a lawyer at that point. With LLCs and corporations, I would not recommend doing it on your own. With trademark and copyright, you could try and fumble your way through and probably be okay, as long as everything is very clean. If things get a little messy, then you probably should talk to a lawyer at that point. All right. So, and patents, right. So for patents, this is the patents, you should always just have a lawyer. Patents can be very complicated. And the simple ones, unless you've done your own patent filing before, you probably should talk to somebody who knows what they're doing. All right. So we've covered business structures. We've covered intellectual property. The last topic, when should you contact an attorney? So I don't know if you can see this, but this is a little cartoon of an executioner. He's talking to King Henry VIII, and he says, "Henry, I wish you weren't so cheap and would hire a divorce lawyer." The point here is, don't be so cheap that you don't want to hire a lawyer. But before we even get to that, though, there is a difference between contacting a lawyer and retaining a lawyer. When you contact a lawyer, oftentimes they will be willing to talk to you without actually charging you. This is something that I generally am happy to do. I am happy to have a 10 to 20 minute phone call to answer, broad questions and give you a general idea of how stuff works pretty easily. And you should do that whenever you have questions. Now, and that generally will not cost you a lot, and it can save you tons of money. I have handled cases where it has cost the client tens, if not $100,000, because they did stuff on their own without ever picking up the phone and asking an attorney whether or not it's a good idea. It's very easy to avoid major problems just by picking up the phone. And yeah, a good lawyer is cost effective. So we've kind of already talked a bit about the advantage of doing a corporate structure versus defaulting to a general partnership. You can get into a lot of trouble with a general partnership because of the joint and several liability. And by talking to a lawyer, the lawyer will probably steer you away from doing that. Next example I have here, reviewing a commercial lease at its exception instead of at renewal. I have a client where she did not have a lawyer review her commercial lease when she first moved into a place. After the lease, and she only got like a 3-year lease. This was a retail space. She built up the space. She spent a decent amount of money on tenant improvements. She made the property significantly more valuable. However, when the lease came up, the landlord doubled her rent. And that put her in a very difficult position. A lawyer reviewing a commercial lease, one of the things that I always make sure to do is I make sure that there are multiple options to extend. Because a commercial tenant at the time that the lease is entered into has the most leverage, because generally the property has been sitting vacant and they're trying to get somebody in there, and the tenant is more mobile. They haven't like moved all their stuff and they haven't spent a bunch of money on tenant improvements. They haven't tied their brand to that location. Once you sign that lease, though, all of that leverage goes over to the landlord, and it can cost you a lot of money. And then the last one is basically protecting yourself in the terms of a lawsuit or of a contract versus filing a lawsuit. It will generally cost a few $100s, maybe a couple $1,000s to review a contract. It can cost north of $100,000 to fight a lawsuit. Get attorneys involved early in the process. So when should you contact an attorney? Before you think that you need one. Talk to an attorney at the beginning of the process, not when you think that you need one. And then I have a little thing here, so that even lawyers know that they need to hire attorneys. There's a Supreme Court case. So there's a common saying that a lawyer who represents himself has a fool for a client. Well, if you're not even a lawyer, that makes it even worse. So it's good to have, even if you know everything that you're doing, even if, like, as a lawyer, even if I know everything that I'm doing, even if I understand the topic, it is still good to have an independent third party evaluating the case and framing everything and pushing back and giving another set of eyes on stuff. So that is why you should contact an attorney earlier. The last slide I have here is a slide on when you should contact an attorney. And the idea is, so we have two axes here. We have the more or less liability axis, which is basically talking about, okay, how much money is on the line? How much money could you lose if something goes wrong, or how much money could you make if things go right? So, and you can see that you can see what things are worth more or less money. And then we have the more or less complicated axis. The stuff in the bottom left, those are the things that make the most sense for you to handle, maybe without a lawyer. You still can hire a lawyer for some of this stuff, but that's where it makes the most sense. For complicated stuff, you generally are going to end up hiring a lawyer anyway, but if there's less liability, it matters less. And so that's kind of where that stuff is. And then on the more money side, or well, obviously in the top right quadrant, that's where you really do need a lawyer for whatever you're talking about. On the bottom right, you probably should be hiring, even though it's less complicated, because there's more money involved, you should probably be hiring a lawyer for that because of the amount of money that's at stake. And those are situations where lawyers can really, even if it's really simple and it turns out that, well, if things are really simple, the lawyer probably will not end up charging too much. So these were the topics that we talked about: business structures, intellectual property, when to contact an attorney. If you have any questions, please feel free to give me a call about any of these topics. We handle a variety of different matters. Also, if you need a lawyer for any type of case, whether it's something that we handle or not, I am happy for you to give me a call because I know a variety of different legal professionals that I can refer you to. So that was my presentation. I hope you found it useful. I'm going to turn it back over to our host, and thank you for allowing me to present.
Thank you, Daniel, for sharing your insights with us today. We truly appreciate your time and expertise. And thank you, everyone, for tuning in to today's webinar, Business Entities and How to Form Your Business. We are grateful for your participation. All the relevant resources will be available in our description box under this video. If you would like to learn more about Asian Inc. and our business development team, visit our website at asianinc.org/business. And follow us on our social media. We will be hosting more webinars in the upcoming months. Please subscribe to our newsletter for updates. That concludes today's session. Thank you for joining us today. Have a great day.
Thank you, everybody. Thank you, Daniel, again.
Thank you. Thank you, Daniel. Thank you, everyone.
You're welcome.